Mr. Simons, do you have your next exhibit that you'd like to introduce?
Yes, Your Honor, just briefly first, in light of the court's ruling admitting PX 39, uh, plaintiffs would like to clarify that PX 26, the affidavit of Ms. Ezekpe, was relied upon by Professor White during the course of writing her reports and forming her opinions. She was also cross-examined on this exhibit by the legislative defendants when she was on the stand. And given that the PX 39, the article was referenced by Professor Laludis during the course of writing his reports, plaintiffs would just like clarification on whether PX 26, Mrs. Ezekpe's exhibit, would be admissible under this standard.
So I guess the long and short is you're asking me to reconsider our ruling on PX 26.
Yes, Your Honor, I am. And also just I'd like to point out that Mrs. Ezekpe was deposed in this matter, and that is also a point of consideration.
All right. Give me just 1 second.
Thank you, Your Honor.
Well, before we rule on that, Ms. Moss, would you like to be heard on that further?
Yes, Your Honor, briefly, if I may.
All right.
So an out-of-court statement by a non-party witness is very different than a learned treatise, which has its own specific exception to the hearsay rule itself. So I don't believe it's appropriate to equate those two things. Of course, experts rely on hearsay, and that is an understood and accepted part of the rules. That is very different than that hearsay being allowed to be introduced into the record. And the prejudice is clear in that they're trying to have Ms. Ezekpe's testimony, which has been untested before the court under cross-examination by the legislative defendants, put into the record. And so again, if they wanted her testimony, they could have called her to the stand as they originally indicated they were going to do. They made the choice not to do that, and therefore they should now be able to introduce her testimony simply because their expert relied upon it. It was also made clear their expert did not rely upon and was not provided the deposition of Mrs. Ezekpe, which would have potentially informed those opinions as well. And so for those reasons, we would ask that the court maintain its ruling that it is not admissible.
Hold on just 1 second. All right. We are going to change our ruling as to the admissibility of PX 26, and we're going to overrule the objection to it and admit it, but we're admitting it for the limited purpose and the sole purpose of supporting Professor White's expert opinion in that it is a document that she relied upon in forming her opinion. We're not admitting it for the substance of the document. We're not admitting it for the truth of those things asserted in it. So we're not admitting it as substantive evidence. We're admitting it for the sole purpose of it is a document upon which one of your experts relied in forming their opinion. So does that make it clear? And I think that is consistent with our admission of PX 39. And so it's probably accurate to admit it for that purpose, for consistency, if nothing else.
Thank you, Your Honor. Your Honor, the next exhibit on my list is JX746. This is an email chain, and Your Honor, the only reason that this exhibit was not moved into evidence earlier in the trial with the other joint exhibits is that it previously had a highly confidential designation. The legislative defendants and state defendants waived their highly confidential designation of this material, so we would like to just move it into evidence.
Is there any objection to that?
No objection from the legislative defendant, Your Honor.
How about for the state defendant?
No objection from the state, Your Honor.
Mr. Steed, I'm sorry if I'm not always calling on you. So if you
That's
ever
all right, Your Honor.
If you ever wish to be heard or have an objection about some of these back and forths, please chime in. I don't mean to skip you. It's just
No, Your Honor, it's working fine. If I have something to say, I'll speak up.
fair enough.
Thank
JX 746 is received into evidence.
Thank you, Your Honor. Next on my list is PX54. This is an email from to Karen Brinson Bell. It was an exhibit that was introduced during her deposition, and the portions of which were played earlier in the proceedings. Your Honor, we believe this should come in as a party admission. The State Board of Elections is a party to this election, to this case. And for that reason, we believe the party admission rule applies here.
And Your Honor, if I could have one moment to pull up that particular exhibit.
It's PX 54, is that right?
Yes, Your Honor, PX54.
And it's Karen Brinson Bell's entire deposition?
No, Your Honor, this is just it's an email to Karen Brinson Bell, and it was introduced as an exhibit during a portion of her deposition that was played earlier.
And I apologize, Your Honor, I'm having difficulty finding it in my file here. If you can give me just 1 minute.
Sure.
Your Honor, I can ask my colleague Ashley to pull this exhibit up for every participant if that would be easier.
And I do have it now. Thank you. We do not have an objection to this exhibit, Your Honor.
PX 54 is received. What's your next one?
The next exhibit is PX55.
Your Honor, the state defendants have no objection either.
Great, thanks.
Thank you, Your Honor. So yes, the next exhibit I have is PX55. It is also an email to Ms. Bell. It was also introduced as an exhibit during her videotape deposition, and plaintiffs believe it is also admissible as a party admission.
Your Honor, the legislative defendants do object to the admission of this exhibit. Unlike the previous one, PX54, this exhibit is an out-of-court document. It's hearsay. While there are parts of it that may be a response from the state board, and I'm not even sure if that's true, the substance of the exhibit is not from the State Board of Elections, so it is not an admission of a party. It is from an outside entity called VR Systems and a woman from that organization. The fact that Ms. Bell was questioned about it in her deposition does not remove the fact that it is still hearsay and is not a document of the state agency. And so for those reasons, we object.
Mr. Steed, you wish to be heard?
Your Honor, we have no objection.
Your Honor, may I briefly be heard?
Well, let me say this. Part of what's going on here with me and perhaps the other judges as well is that when you're in court and you're hearing evidence and witnesses are on the stand testifying and they identify exhibit, most of the time it makes good sense to introduce that exhibit right then because you have a frame of reference, you have a context within which it's talked about, and you can, it's right there on your plate in front of you. And so the problem sometimes coming in doing it this way is that we're talking about witnesses who testified a couple days ago now, I think, and it's hard for me, for one, to remember how the exhibit was used and what was showed during the testimony and that sort of thing. And so I'm just me personally, I'm not speaking for the other judges here, but me personally, I'm having a hard time putting this particular exhibit into context and really distinguishing it between PX54. PX54, I was told, was an email. It was introduced during the course of her deposition. It was played before the court. Now, PX55 is an email to Ms. Bell. I mean, generally, if it's a deposition and you introduce it as a 30B6 deposition and you have an exhibit to that deposition, which was introduced as part of the deposition and made literally an exhibit to the deposition, then when you introduce the deposition, you introduce all the exhibits that are attached to it. And so I'm trying to think of this in those terms. And so if somebody could speak to that, I would appreciate it, at least for me personally, as to
Well,
how
Your
this.
Honor, sorry for interrupting, Your Honor, but I can bring the exhibit up now so that it's visible for the court and the parties, if that
That'd be
would be
good.
easier. Thank you. Ashley, could you please bring up PX55? Thank you. And Your Honor, I would also just like to point out that this exhibit was shown to Ms. Bell during her video deposition, and it also appeared on the screen in court when her video deposition was played. So the plaintiffs are not trying to hide the ball here. This exhibit was displayed in court in the course of her deposition as plaintiffs followed the court's instructions to play the video deposition or the portions of the video deposition that the parties agreed to designate. And just briefly, Your Honor, this email is a record of business conducted regularly by the state board, which is a party to this litigation. Therefore, we believe it's acceptable as a party admission and also as public records kept by the state agency.
Okay, Ms. Moss, you wish to be heard further about it?
I would simply say, Your Honor, that if they would scroll down, it'll be clear that while this was an email that was received by Ms. Bell, unlike the prior exhibit that was admitted, there is no response from the State Board of Elections to this email, which the reason we did not object to the prior email is we agree that the response from the State Board of Elections constitutes admissions of a party opponent. This is simply a statement from an individual who is not a party and who was not here testifying. We're not suggesting it's not authentic, that it's not in fact an email that was received by Ms. Bell, but in terms of the truth of the matters being asserted here, we don't believe that that has been established or meets the evidentiary standard to overcome the hearsay rule.
Your Honor, I'd just like to point out that this email begins with the phrase "as promised," which suggests that Ms. Bell requested this information.
All right.
Your Honor, the state defendants agree with the legislative defendants that this is not a party admission, but as plaintiff said, it would be a public record. So it is what it is. It's a statement by a vendor, not the state board.
The objection to PX55 is overruled. The court will receive PX55 as an exhibit to the deposition of Ms. Bell.
Thank you, Your
What's
Honor.
next?
Next on my list is PX73. Ashley, could you put that up as well for the court? This is the tweet from Senator Ford, and plaintiffs are not seeking to admit this tweet, this exhibit for the substance, only to show that Senator Ford issued this tweet.
Any objection?
No objection, Your Honor.
No objection, Your Honor.
PX 73 is received.
Thank you, Your Honor. Next is PX 79. Ashley, could you bring that one up too, please? Again, plaintiffs are moving for this exhibit into evidence not for the truth of the statements, only to show that the email was sent. The bill attached to this email chain was a public record. There's no dispute about the authenticity of the bill attached to this email, and Senator Ford was asked about this bill during his testimony, and he authenticated it.
Any objection?
No objection.
No, Your Honor.
PX 79 is received.
Thank you, Your Honor. Next is PX 81. If we could bring that up, please. Your Honor, this is an article from the Charlotte Observer that describes Senator Ford endorsing Senator Tart.
Any objection?
No objection, Your Honor.
No, Your Honor.
PX 81 is received.
Thank you, Your Honor. Next is PX 88. We could bring that one up too, please. This is an article from the Daily Tar Heel, which describes the voting members of the UNC Board of Governors, including former Senator Ford.
Any objection?
No objection, Your Honor.
No objection, Your Honor.
PX 88 is received.
Thank you, Your Honor. And last on my list is PX 101. We could bring that up, please. These are this is the text of the designations from Ms. Bell's deposition. These are just the designations of the text of the video designations that were played earlier in the proceedings.
Okay, so this gives us in writing those portions of the deposition that were played to the court.
That's correct, Your Honor.
Any objection to that?
Your Honor, we don't have an objection in theory. I don't believe that we've been provided this exhibit before, so I would like the opportunity to just confirm that it's accurate before we agree that we have no objections.
Well, how about I admit it, then after you look at it, if you see some discrepancy, I can come back and readdress it.
That would be fine.
Any objection from the state defendant?
We don't have an objection to the transcript, only just the plaintiff's representation that although it bears a confidential designation, there's not anything in this transcript that would fall under the confidential designations.
PX 101 is received with an asterisk that defense can come back later and challenge portions of it as not being to those portions which were actually played to the court.
Thank you, Your Honor. I believe that's all the exhibits on that I have. May I just check my list quickly to make sure I'm not missing anything?
Sure.
Your Honor, I have no further exhibits to move for admission at this time. Thank you.
If you all need, if the plaintiff's counsel need to sort of huddle and talk about whether you've got everything, crossed all your T's, dotted all your I's, ready to arrest, introduce any evidence, I'll be glad to give you, 5 minutes if you want to do that. But if you've already done that and you're ready to go forward, I'm ready for that too.
Yes, Your Honor, we would like that opportunity.
Yes, thank you, Your Honor. If we could have maybe just a 5-minute recess.
Sure. We'll take 5 minutes, come back at 11 o'clock.
Thank you, Your Honor.